suggesting, Your Honor.
It was. It was. You said he can't shirk his discovery responsibilities by signing a document, sending it off, and then say, I don't have it. So right now, your credibility with me, Mr. Axelrod, is about none, if you understand that.
Right, Honor, if I may respond to that. And just like that, the courtroom snaps into focus on a lawyer who is about to be told, to his face, that his word means nothing. A judge stares down a CNN attorney and says the 4 words no litigator ever wants streamed to the world: your credibility is none. Stick around, because before this hearing is over, that same judge doubles a fine, threatens a career, and forces an apology that never fully comes. Here's what you're watching. 2 legal teams tangled in a 2.5-year civil case, accused of the exact same discovery violation they'd spent the morning accusing each other of. A mysterious document. A subpoena nobody agreed was really a subpoena. And a judge who has clearly run out of patience for lawyers acting like this is their first rodeo. It starts with a courtesy copy. CNN's attorney, Mr. Axelrod, explains that his team sent a witness named Ralph Otto what he calls a heads up. An advance look at a trial subpoena, so that when Otto landed in Florida, service would go smoother. Reasonable enough on paper.
Our civil board fleet that he did not share with us. I can share that with you too.
Your Honor, if I may respond to that, my cover email to Mr. Otto states, it is our understanding that you may be arriving in Florida to testify. When you land, we intend to serve you with a trial subpoena, requiring your attendance, and that requires you to bring certain documents with you when you testify. To that end, we are attaching a courtesy copy of our intended subpoena in advance so that you can have more time to gather the documents, and then when served, it will make compliance easier for you. We then ask him to tell us when he's arriving to make it more convenient for him and the process server, or ask if he will accept it over email. This was not service of a subpoena. This was service of a courtesy copy so that when he landed, we would hand it to him and then we would bring it to your attention to say, and to them, and to say, hey, we have now tagged Mr. Ralph Otto in Florida with tagged jurisdiction. He now has a valid trial subpoena to produce documents to us. We were never able to tag Mr. Otto, and so we never ended up serving the subpoena. I was very clear it was a courtesy copy, so I take...
Opposing counsel doesn't see it that way. He calls it a half-disclosure, a subpoena dressed up as a favor. And here's the thing, for about 30 seconds, Axelrod's explanation almost tracks. Courtesy copies happen. Lawyers give each other a break sometimes. You could almost believe this was just professional courtesy between adults. Then the paperwork gets read out loud.
Before you do that, is that what the cover letter said?
I don't have the cover letter in front of me, but there's a certificate of service that says, I hereby certify that the foregoing documents was furnished to all counsel of record by electronic mail on this 6th day of January 2025, the same day that it was sent to Mr. Ralph Otto. And it was never served on us.
Or may I approach? Here's the cover letter. My paralegal prepared a courtesy copy. It says it. On my honor and as an officer of the court, it was a courtesy copy. We set it straight out. It is true there's a certification in there, but that's just because I asked my paralegal to prepare a subpoena so we could send it to her, and she simply filled it out. Your Honor, also...
A certificate of service. A cover letter. Language that doesn't quite match the story being told about it. And the judge starts asking the kind of quiet, specific questions that tell you he's already found the hole in the argument before anyone else has. Because underneath the subpoena fight is the real fight. A signed security agreement between the plaintiff, Mr. Young, and a company called Helios Global. CNN side argues Young hid it, lied about it, missiled a jury about ongoing work that never happened. Young's attorney fires back with something simple and devastating. Her client had signed the document and mailed it back for the company's signature. He never had a countersigned copy to produce, because it never came back to him.
I feel compelled to simply correct the record because my client has been labeled a liar over and over again. The document, Mr. Young said it was a wet signature, and as you'll see on the document, it is not signed by Helios Global, which means, as Your Honor pointed out, he executed it and then sent it, he mailed it back to Helios Global for execution. So he did not have it to produce in discovery. My client has never lied in this litigation, and in fact, when asked about whether he signed an agreement with Helios Global, admitted it on the stand. Mr. Axelrod was not prepared for that admission, went to impeach him after there was nothing to impeach. And if the court looks at the transcript, you'll hear my objection. He says, I'm going to impeach him. And I said, what are you going to impeach him for? There's nothing to impeach. So he has told the truth over and over and over again. The only thing he hasn't told the truth about is that he didn't...
You can't be blamed for withholding a document you were never handed. And then comes the moment this case turns on. Helios Global had sent CNN's team a letter, months earlier, stating plainly that Young's security clearance had been administratively dropped back in 2022. CNN had that letter. Young did not. So when Young testified on the stand that he believed he still held his clearance, CNN's team let the jury sit with that belief a little longer than they should have, and then called their own expert to say on record that Young was cleared to work. They knew otherwise. They had it in writing.
And Your Honor, they put an expert on the stand yesterday that said he still has a security clearance, he's grateful, he can do all the work he wants. They knew it's not true. They had their expert get on the stand and say, he's got a security clearance, no problem, he can get work. They knew it was not true. We did not, they did.
That is false. Mr. Young testified he still has a security clearance. We had no idea that that's not true.
Your Honor, if I may, they knew it's not true because Helios Global told them it's not true on January 2nd, 2025. In their letter, they said, we retained Mr. Young's clearance through approximately November 2022 in the event these requirements reemerged. But they did not. Ultimately, we administratively dropped Mr. Young from our security clearance roles, thus ending any relationship/affiliation. So CNN knew that there was no security clearance in place, something we didn't know because we didn't.
That's the naming moment, and it doesn't arrive with shouting. It arrives with the judge quietly doing math out loud, walking back through his own trial transcript, matching what was said in front of the jury against what he now knows was known and unsaid.
We should be able to clear the record. The jury should not be misled.
Your Honor, you can't be prejudiced by introduction of a document that you knew existed. And you already found in the spoliation order that as of December of 2021, Mr. Young knew he was going to be bringing this lawsuit or was contemplating it. You can't get around your discovery obligations by signing a document, then sending it off and saying, I no longer have it, can't produce it. That's what happened here.
A courtroom builds arguments on what people don't say as much as what they do, and this one had a gap wide enough to walk a jury through.
Representations that are being made, and they're being made by both y'all. And maybe they're not 100% lies, maybe they're leaving out a little bit of the truth in making representations, so you can carefully say, well, I didn't exactly say that. But you said he's lied to it because he doesn't have any work, but he had no proof that he had work because you're arguing that he signed a security agreement so they could hold his security clearance. But I didn't lie and say you.
The finale is where the pressure finally breaks. The judge reads back his own prior warnings, the $100 fines, the comments about last-minute discovery, the running theme of surprise evidence dropped at the worst possible moment for the other side. He notes, almost with disbelief, that the same rule both sides accused each other of breaking, notice requirements for non-party document subpoenas, had been broken by both sides, simultaneously, while each pointed fingers at the other.
Remember reading two motions to quash that verbatim said Rule 1.351 expressly provides the rule that is the exclusive procedure, in quotes, the open quote, exclusive procedure, close quote, for obtaining documents from non-parties without a deposition. Your subpoena for trial to whomever at Helios had a production request. The motion also says that the motions that I remember reading said that 1.351 requires the notice to the other side. How were you not conducting discovery pursuant to 1.351 in sending a subpoena ducis tecum to Helios Global without giving notice to the other side?
Judge, I'm going to take ownership.
And then it lands. Your credibility with me, Mr. Axelrod, is about none. Not raised, not dramatic, just final.
You were saying that he completely lied and misrepresented despite the fact he acknowledged that he had a security clearance with Global, which again is another misrepresentation of the court which supports your argument that you were being made. So right now your credibility with me, Mr. Axelrod, is about none, if you understand that.
I do. I certainly do, and I apologize if you feel that way. I apologize if you feel that.
The apology that follows is careful, hedged lawyerly. I apologize if you feel that way, and the judge doesn't buy it for a second.
Certainly wasn't my intention.
Yeah, well, you said, oh, I never said that. Well, no, you did. So, today you said I never said that, but that's what the transcript from last week was representing. I'm reserving on any other sanctions pertaining to this matter and other matters against lawyers and parties in this case. But at least to resolve the issue for this morning.
He doubles the fine for personal insults between counsel, from $100 to $1,000, and lets the witness testify by Zoom rather than reward anyone further with delay.
And let me say this, I mean, y'all made a lawyer like that in Philly or New York or DC or wherever the heck it is, or Miami. We don't lawyer like this around here. Y'all may have handled some big cases. We're not going to play the shenanigans anymore in this case. Y'all both understand that?
Yes, sir. Yes, sir.
And I'm upping the fine for personal insults to $1,000 per time from $100.
What this hearing really exposes isn't a legal technicality. It's a familiar, human pattern. The moment when two people so convinced of their own righteousness end up committing the very sin they accused the other of, and neither one notices until someone with real authority points it out. Anyone who's ever been mid-argument, so busy building a case against someone else that they missed their own hand doing the same thing, will recognize this. The judge didn't just rule on a discovery dispute. He held up a mirror neither lawyer wanted to look into. And somewhere in a Florida courtroom, the price of not looking just went up to $1,000 a word.